Hi, I'm Garrett Epps, legal affairs editor of the Washington Monthly and a recovering constitutional law professor. So here's our hypothetical today. What if America held a huge constitutional confrontation and the Supreme Court just didn't show up for it? I'm asking this question in connection with a case called Trump versus Casa and some other cases consolidated with it. These cases challenge Donald Trump's executive order, the famous order that's attempting to strip citizenship from babies born in the United States to undocumented and even some perfectly lawful immigrant parents. Now, the first round of this case will be argued before the Supreme Court this Thursday, May 15th. Trump's order to end birthright citizenship for these babies rests on the grounds that supposedly everybody, and I mean everybody, Congress, the Supreme Court, and the executive branch has been reading the citizenship clause of the 14th Amendment completely wrong for the past 150 years. The clause says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, Trump and the far right of the Republican Party have decided that all doesn't mean, all. Undocumented immigrants, and as I say, even some perfectly legal immigrants, aren't subject to the jurisdiction, supposedly because they're not in the country on a permanent basis. Just so you know how radical this new definition is, as I read it, Kamala Harris would not have been a U.S. citizen and thus could not have run against Donald Trump. Some immigrant families, immigrant rights groups, and some U.S. state governments have gone to court challenging Trump's order, and lower courts across the country have blocked it as a direct violation of the Constitution. The upcoming argument mostly concerns whether a lower court can do that. Can one district judge block an executive order everywhere in the country? But there's an underlying issue that the court can't decide the case without at least looking at. And that issue is this new definition really the original meaning of the clause? The court can't resolve the issue of nationwide injunctions without at least looking at that issue. But what if the court doesn't have to resolve it? What if, in fact, good judicial practice suggests that the court shouldn't even reach that constitutional issue? Earlier this month, 183 members of Congress filed an amicus, or friend of the court brief, with the Supreme Court arguing exactly this. Trump versus Casa, they say, is a case about a statute passed by Congress. And if there's one principle everyone agrees on, it's that Congress has the legislative power. Congress writes the statutes. The president, no president, this one or any other, has the power to write the statute on his own hook. This president does not have the power to rewrite a statute on his own hook just because he thinks he has a better idea. And that, the brief argues, is what Trump is trying to do. What does that mean? Well, consider how a baby born in the U.S. gets legal proof of citizenship. Right now, a birth certificate showing the name, time, and place of birth is what that baby needs. The Passport Bureau would issue a passport, which is proof of American citizenship, both abroad and in the U.S. So, do those children get their passports because the 14th Amendment says they must? No. The amendment and the citizenship clause aren't directly involved in that transaction at all. Why is that? American-born babies get their citizenship through a provision of the Immigration and Nationality Act of 1952, what we call the INA. That provision is United States Code Title 8, Section 1401A. And the section says, the following shall be nationals and citizens of the United States at birth, a person born in the United States and subject to the jurisdiction thereof, end quote. Okay, wait a minute. Isn't subject to jurisdiction the very same language that the 14th Amendment uses? Well, yes, but pay attention because this is how lawyers earn their pay. To a lawyer, the fact that the language is identical doesn't mean it has the same meaning. Trump and the extremists around him are arguing with a more or less straight face that nobody knew the true original meaning of the amendment until the 1990s, when conservative lawyers launched it as a weapon against immigration. But the amendment was passed in 1868, and from then on, most people assumed that anyone born in the country was subject to the jurisdiction of the United States, except for two small exceptions. One, children of diplomatic families who were sheltered by diplomatic immunity, and children born to certain Native American tribes who were sheltered by treaties. That was the meaning the sponsors of the amendment spelled out in congressional debate. And in 1898, the United States Supreme Court, in a case called United States versus Wong Kim Ark, held that that was the meaning of the clause. No matter how Wong Kim Ark's parents got to the U.S., he was an American citizen. Congress passed statutes with that subject to the jurisdiction language twice, once in 1940 and once more in the INA in 1952. Both times, the record shows, the members agreed. Subject to the jurisdiction means everybody except diplomats' children. Native babies got citizenship in a statute in 1924. 1401A is the law under which American babies get their citizenship, not the amendment. The citizenship clause is very important, but it's important as a limit on what Congress can cut back, a limit on how it can limit citizenship, not a limit on how far Congress can extend it. Since 1789, under the Constitution, Congress has possessed what the Supreme Court calls plenary power over matters of immigration and citizenship. Congress can grant citizenship to groups of its choice. In fact, in 1790, the very first Congress passed a statute making children of American citizens born beyond sea, that is, in foreign countries, natural-born citizens. Throughout the 19th as well as the 20th century, Congress has used this power to grant citizenship at birth to new groups. Tribal Indians in 1924, but also babies born in Puerto Rico, babies born in the U.S. Virgin Islands, babies born in the former Canal Zone, babies born in Guam, among others. In 1401A, Congress granted citizenship to all U.S.-born children, except those born into diplomatic families. All of them, because that was the meaning of subject to the jurisdiction in place when Congress passed the statute. Why does this matter? Well, the brief argues the right way to look at these cases is that they are a dispute about how to interpret 1401A, not the citizenship clause. And interpreting a statute is a very different game from interpreting the Constitution. We all know that we're living in the era of constitutional originalism. Many originalist constitutional lawyers, scholars, and judges these days seem to act a little bit like the paranormal investigators on reality TV. They skulk about the haunted house of history and claim to derive meanings from electrical fluctuations in the air, faint whispers in the dark, half-seen images in supposedly magic mirrors. Originalists take these fragments and piece together what they call the original intent, or the original understanding, or the original public meaning of the constitutional provision. But those terms are a fiction. What they supposedly mean is that we can figure out what an ordinary person in 1868 would say if we could somehow bring them back to life and ask them what this part of the 14th Amendment meant to them. Statutes are very different animals. The intent or understanding we are seeking is not ghostly at all. It is not that of a fictional person in the street. It is that of the very real, very particular, very specific Congress that passed the statute. What matters is what's written in the code and the legislative record they assembled. The law is what Congress enacted in 1952. And with 1401A, we have loads of information about what Congress understood itself to be doing. Committee reports, witness testimony, floor debates, all explicitly, in so many words, reveal that to Congress, the statute captured the Wong-Kim Ark rule. All children born in the U.S. except children of diplomats. Now, 4 decades after the passage of the INA, a bunch of conservative academics heard voices in the air that told them the clause actually always meant something quite different. Constitutionally, that argument is kind of a stretch, to say the least. But notice, the brief argues that even if they are right, that doesn't change what the statute means. Everybody knows what Congress had in mind in 1952. Everybody knows what the words of the statute meant then, and everybody knows what they mean now. All children, with the small exception of diplomats' children. Immigration status of the parents doesn't matter. Honestly, why should it? Newborn babies can't violate the law by being born. In a free democratic country, guilt isn't something that's handed down from parent to child, and neither is hereditary inferiority. If Trump doesn't like that, there is something he could do about it. Article 2, Section 3 of the Constitution gives him the absolute power to recommend to Congress such measures as he shall judge necessary and expedient. That's right, he can ask Congress to change 1401A. And would that change get through Congress today? Probably not. That's probably why Trump is trying to change things by a supposed executive order. It's a funny thing about executive orders. In 1952, the same year the INA was passed, the Supreme Court decided a famous case called Youngstown Sheet and Tube versus Sawyer. During the war in Korea, President Truman faced a strike in the steel industry, a strike that would cripple production of ships and planes for the war effort. So, acting on what he said was his own authority, he sent federal officials to take over the private steel mills and keep them running. Youngstown Sheet and Tube Company went to the Supreme Court. The court slapped the president down. There was no statute permitting the president to seize private businesses during a strike, the majority said, no matter how much he wanted to. The court's majority told Truman to give the mills back. In a famous separate opinion, Justice Robert Jackson wrote that the president's main job is to execute laws Congress makes. Congress had provided him with a number of tools to deal with strikes. Seizure was not one of them. Congress hadn't given him the authority to seize. As Jackson analyzed it, a president can ignore statutes of this kind only in an area in which the Constitution blocks Congress from having any power at all. As if, Jackson said, the Constitution disables Congress from acting on the subject of these statutes. A classic example would be Congress ordering the commander-in-chief to invade a foreign country on a certain date. They simply don't have that power. But in the immigration context, as we saw, Congress isn't disabled and it can't be disabled. In fact, Congress, not the president, has all the power over immigration and citizenship. And for the president to act on those matters, he has to show that Congress has delegated that power to him. Is there a statute that lets the president rewrite the citizenship rule? I certainly haven't found one in so many words. Now, Trump may claim that the existing statutes, if you hold them at the right angle and put them in the right light and squint kind of a little bit, give him that power. But that claim is going to run into a recent Supreme Court rule invented by the conservative majority called the Major Questions Doctrine. If the president wants to take measures of vast political an economic consequence, the doctrine says, he can't rely on implication. He has to show a specific and explicit grant of power in a statute. Is there such a grant in this case? Well, I've looked for one, and I can only quote the famous words of Justice Samuel Alito in another context. Zero. None. Now, I've seen a lot of debate about whether the court's new conservative majority is actively on Trump's side, whether this is, in effect, a MAGA court. I don't think so. I think what these justices care about more than anything is protecting the court itself. Jumping into the citizenship clause debate when they don't have to will get them into hot water with one side or the other, no matter what they decide. And since the first days of Trump's second term, this court has shown a desire to dodge big issues by ruling on technical questions like whether the plaintiff has sued in the right court or whether the plaintiff has used the right form of action or whether the judge used the proper word, effectuate rather than facilitate, for example. Here's a dodge that lets them split the difference. Maybe Trump is right about the clause, the court could say. That doesn't make him right about the statute. Go and get Congress to change the statute, and then, and only then, we will consider the original meaning of the citizenship clause. That would spare both the court and the country a world of hurt, at least for now. And as the congressional amicus brief points out, it is the right thing to do.